Awesome. Thank you, Jennifer, for the introduction. We're super happy to be here today with you guys kind of over the lunch hour and chat about the virtual workplace and supporting employees as we transition back from remote work to in the office. We thought we'd kind of start today with going over some of health and safety orders, what's been in place, some changes that we see coming up, and then walking through accommodations and things to look out for as we have employees coming back to the work site. So the health and safety orders, these were established back in March 2020 and essentially is what marked the beginning of what we would call the pandemic for employers. Right now, we're in an interesting time period because we were all wondering what would California look like, after June 15th. And especially as an employment attorneys, this is something that we are regularly watching and updating our clients on. So recently on June 11th, the governor issued an executive order. And in the order, he explained that 54.3% of eligible Californians had received a full course of the COVID-19 vaccination. And as a result, he went ahead and rescinded the stay-at-home order, as well as the Blueprint for a Safer Economy, which previously directed the state public health officer to issue essentially a risk-based framework for reopening the economy. What we've included here in this chart is just some links, which we can circulate the links later, but regarding the California Department of Public Health and what requirements they had for the general public. And we find that as employers, we need to be aware of those requirements as well, and those articulated in Cal OSHA. So recently, if you view the California Department of Public Health website, it tells you that masks are not required for fully vaccinated individuals, except masks are required regardless of vaccination status in certain situations like public transit, indoors at K through 12 schools, childcare, youth settings, healthcare settings, and correctional facilities, homeless shelters, and emergency centers. So we're still watching what's going to happen after June 15th and seeing how we can best adapt, especially in light of the Cal OSHA emergency temporary standards. So they were adopted in November 2020, and those standards that were adopted in November 2020 remain in effect. There's actually voting that's going to take place tomorrow, so stay tuned because we plan to, for those of you who are interested, we'll have a handout that you can follow up with Christine and I directly, addressing some of the changes, the big ticket items that will be changing if the regulations are amended. And if they are amended, we expect to see those regulations go into effect by June 28th. And so just for those of you, the Emergency Temporary Standards, or ETS, they regulate essentially workplace safety and those requirements regarding COVID-19. We found that, especially as an employment attorneys, a lot of clients were really interested. Well, how can I get all of this information? There's so many different sites, there's so many different sources. And so recently, California created the saferatwork.covid19.ca.gov there for employers. And this is actually like a screenshot of what it looks like. So for those of you who haven't visited it, you're able to click these blue boxes and it takes you to links. So for example, there's more information on COVID-19 testing, provides you a direct link into Cal OSHA's emergency temporary standards, what to do if you have a worker who has been sick or exposed to COVID-19. And so this is sort of the best attempt to put the information in one place. It's not foolproof, or I should say it's not, you can't find everything there, but at least it's a start, right? We've got a couple boxes for you guys to look into. So one thing, and we hope that you've been considering this, in the last year, is developing policies and protocols to ensure that employees are safe. And this is particularly important as we see more employers bringing their employees back to the work site. I saw a meme or some sort of GIF that talked about return to the office or return to work. And people were saying, well, we never really stopped working, and we haven't really taken vacations either. We're just coming back on site. So I think it's important for us to be mindful that that really is a lot of our employees' feelings, especially those who've been fully remote throughout the pandemic. But when you're developing policies and protocols, besides checking in, with your local council, you'll want to make sure that you're looking at the state and local orders, reviewing the CDC state guidance, looking at what you can do in terms of cleaning and disinfection, training your employees and training your managers on how to limit the spread, screening for symptoms. And we find that it's really important to develop these policies because a lot of litigation actually stems from retaliation claims and having to do with whistleblowers. So for example, an employee saying, I didn't feel safe because my company, doesn't have a site-specific cleaner and they don't disinfect, or perhaps we have policies in place, but we're not actually following them, or our managers aren't following them. And so now these employees are complaining to HR and saying there's an issue. Well, now if you terminate the employee the day after they make this complaint, you might have a little bit of a timing issue. So it's something to be mindful of when you're considering policies. There's a lot that goes into it. And Christine and I are definitely here to help, but if you have other counsel, it's great to check in with them as well to make sure those policies are comprehensive and are covering what you need to. What we were seeing with leaves during COVID and sort of, what applied, as I mentioned, we have the emergency temporary standards, which requires employers to create a COVID prevention plan, provide training and instruction regarding to COVID-19, report COVID-19 outbreaks, and also track COVID-19 cases in the workplace. We expect to see some changes with respect to those regulations again, but the voting's tomorrow, so we can't tell you now. One of the big topic items that we've seen is exclusion pay, and if an employee does come back to work, but then they're exposed to COVID-19, what happens? Well, if that employee was exposed but is available and able to work, and the exposure occurred in the work site, then they may be required to be excluded from the work site for up to 10 to 14 days. And this extended period is something that employers were concerned about. Well, what do we do in terms of compensation? The emergency temporary standards explained that this exclusion leave would apply, and if it did, then you must maintain the employee's pay, their benefits, and other rights and benefits for their position. We have seen, though, that you can coordinate this emergency temporary exclusion pay with other leaves, with paid sick leave. Another law that came into effect was the statewide supplemental paid sick leave, and this applied to employers who employed 25 or more employees. There was no length of service requirement for these employees, and it technically expired as of December 2020, but then recently the governor in March 2020 made it retroactive to January 2021. And so full-time employees would be entitled to receive up to 80 hours of paid leave. Part-time employees, it's based on sort of a formula which depends upon the schedule. And the eligible reasons under the statewide supplemental leave, which was reenacted and essentially retroactive to January 1, the reasons are pretty similar: quarantine or isolation, or if you're advised by a healthcare provider that you need to quarantine, or perhaps you're caring for a family member and subjected to quarantine. One of the new reasons is that you can also use this leave if you're being vaccinated. You need to take leave to obtain the vaccination, or perhaps if you have symptoms as a result of the vaccination. It's also important to remember that, in 2020, a number of local cities and ordinances, they prepared their own supplemental policies to fill the gap between essentially the Families First Coronavirus Act and then California's Supplemental Paid Sick Leave Act. And it's important to note that some of these cities here actually continued into 2021 and still have requirements for the essentially perceived gap in the laws. And then finally, don't forget about just California paid sick leave. Of course, you know, if an employee is sick, they can use their paid sick leave time to take off. And this would be under the Healthy Workplace Health and Family Act. And then finally, what to do if an employee has exhausted everything, or perhaps they don't qualify for some reason. We still have the California Family Rights Act, which as of January 1, 2020, the law previously applied to employers with 50 or more, and now it applies to employers with 5 or more employees. So this is a big difference because those employers who typically didn't have to worry about the California Family Rights Act, now you do. And this allows eligible employees to take up to 12 weeks of unpaid job protected leave. It's similar in nature to FMLA or family medical leave, but it is more expansive. All right, so now we're going to transition to returning to the workplace. We've created some polls for you guys to make this a little bit interactive. So if you could go ahead and text 22333. You'll use that number, and then you will type in Sammie, S-A-M-M-I-E-J-L, one word. We'll give you a second to go ahead and do that, and it'll essentially register your phone, and then you'll be able to participate in our polling questions. And hopefully they work. You never know, though. We still have technical difficulties, I'm sure, just like most of you do. All right, so our first poll is, how many days per week do you want to work from home? And I'm going to text too, just so that I'm accountable and interacting. Okay, we'll give it a few more seconds here. And this is more just to get a pulse to see, you know, what are people interested in doing? Because we find, well, if I want to work from home 2 to 3 days per week, it's likely that some of my employees will want to work from home the same amount. And how are we adjusting to this as we return to the workplace? All right, Christine, let's turn it over to you.
So returning to work, and I think the big thing here is you're going to hear me say this several times throughout this presentation is flexibility. And our little comic there is, I'm working remotely, you're not even remotely working. And I'm sure we have issues come up where an employee is purportedly working remotely and you don't really think they're being all that productive. So a little fun there. And some interesting statistics. Before COVID, approximately 20% of the workforce worked remotely from home. During COVID, this increased to 71% of the workforce working at home. And currently, it's estimated approximately 51% of the workforce remains working at home. So we are more people working at home than pre-COVID, less than in the middle of the pandemic. And one important thing to consider as we're talking about returning to work is flexibility. Some people, as we saw, might be really anxious to return to work. Some people might have some anxiety or some apprehension. And the key to bringing the workforce back, if that is something you're moving forward doing, is to be sensitive to all of those issues. So we have another poll anywhere here too. What does your post-COVID workforce look like? And we have A, fully remote, B, hybrid with a mandatory minimum number of days, C, hybrid with a number of days is discretionary, D, pre-pandemic level, or E, unsure at this time. And we'll give you guys a couple minutes to respond. I think this is interesting because one of the things in talking with various clients in different industries is some industries are experiencing issues getting employees back in the workforce, and there's a concern that they may or may not be competitive with the market. So if there's a competitor that is allowing people to work from home and that is something the employee wants to do, there's concern that they need to be consistent with what the market and their competitors are doing. I would say a vast majority of the clients I've spoken with have some form of a hybrid return to work. This is mainly back to that whole flexibility concept and idea where they're not really instituting any full hard and fast rules, but they're really trying to accommodate based off of their industry and specific case by case with each employee. Next slide. So bringing employees back to the workplace, this really comes down to a business decision, and that needs to be a legitimate business reason to bringing people back and how you bring them back. We recommend that you have a policy as to how you're bringing people back to the workplace. This will provide a structure for everybody. A lot has been unknown in the last year, and having some structure as to how you're going to move things forward, it can be really comforting for employees. As you may be aware, there are definitely employees that may have some serious valid anxieties and concerns about returning to the workplace, whether or not they have underlying health conditions. And it's really important to be sensitive to these, again, for several reasons. One, in case it could rise to an accommodation issue. Two, to the extent it could be deemed retaliatory if an employee is expressing concern or complaining about certain policies or returning to the work. And then three, with respect to just kind of on a big picture scale, if a competitor is being flexible, allowing people to return to work, I'm sure we've seen that this is a very fluid situation and people are coming and going with what they need to do at this time. I think it's also important that we emphasize to the employees that it's okay to not be okay to return to work, and that normal is going to look different for everybody at this point in time. Okay. A key thing here is to check in with your employees as you're going through the return to work, and make sure you have an open dialogue and means of communication so you understand what they're feeling, where they're coming from, and can appropriately respond to any concerns that they may have. Some 3 general rules to remember as you're bringing employees back: clean it, screen it, and mean it. So we'll go into the clean, and I think by now we all are pretty well versed in cleaning, hand washing, sanitizing, tissues, disinfecting various work stations, cleaning high traffic areas, cleaning commonly touched surfaces such as doorknobs. If you have a communal kitchen, making sure that it's properly disinfecting. One I found really amusing on this one was daily cleaning merchandise before stocking if possible, or it reminded me of like cleaning the cleaning supplies. I had a roommate in college, and I came home one day from class and she was vacuuming our vacuum cleaner, and I like looked at her and I was like, what are you doing? And she, we're in our 20s, college girls, and I had never even thought remotely to vacuum my vacuum cleaner, and I've never vacuumed my vacuum cleaner, but that was something I saw her doing, and I was like, that's all right, you do you, have fun with that one. But key thing here too is that going back to policies on Clean It, you want to have a policy regarding cleaning, maybe a cleaning schedule, maybe you have a daily cleaning schedule, especially touching on high traffic areas, maybe a cafeteria or a conference room that people are using regularly, and maybe a weekly cleaning schedule for areas that aren't as commonly used, but you want to make sure that you're hitting them. And obviously, if an employee is identified with having a positive COVID case, we want to make sure that that area, any surface that that employee may have touched, is properly disinfected. And next slide, screen it. So, and again, more of the same, I would say, with the daily screenings. Even as we are moving into a more open, things are starting to open up in California. The screening measures are still in place. These are, the temperature checks, the questionnaires before people come in. You should be performing these daily screenings in compliance with CDC and the California Public Health Order guidelines. If employees are uncomfortable coming into the workplace, the flexibility needs to be there to work from home. Other screening and policy recommendations are to limit travel, especially if it's not necessary, asking guests, customers, and employees not to enter if they're feeling symptomatic at all. Currently, under the Cal OSHA guidelines, there is a requirement to contact local public health department if there is a positive COVID case, and to continue to maintain appropriate records with employees regarding the screening requirements. And again, this all comes back to policies and training. Whatever you decide to implement, you want to make sure it complies with the CDC. It is properly and clearly communicated to your employees. And remembering that if you have employees where English is not their predominant language, that policy is communicated in a language that the employee understands, and that everyone receives training on what the proper protocols are. And the last one is meet it. And this goes to, we can have as many great policies and trainings as possible. We actually have to enforce that. And that can be a little sticky, a little challenging at times, especially given people's feelings on wearing face coverings or vaccinations. The important thing is to come up and create a policy that's compliant with the current health order regulations and to equally enforce that across the entire workforce. So a big thing that is still happening is social distancing. If social distancing is not possible because due to the physical setup of your work site, installing barriers, face masks and face coverings, those have not gone away per the Cal OSHA requirements. Cal OSHA currently has set forth examples in situations where a face mask would not be required. They're pretty limited right now. The proposed revisions are modifying that, but right now face coverings are here to stay. Reuse of work shared materials, for example, pens, pencils, highlighters. If you have a workplace that has a retail, you have customers coming in or there's a check-in, I've seen a lot of this where there's an iPad that people are touching, making sure that that surface is cleaned regularly and that you're enforcing that daily cleaning, whether it's daily or after each use. The other thing is, if we're having all of these policies and requirements regarding cleaning and screening, that the appropriate equipment is there for the policies to be executed. One more thing that it is challenging is to try and keep a positive work environment with all these additional rules. Take into account your company culture. We want to make sure that employees feel supported and that this is being done for their safety and not some type of overbearing, controlling place. It's really going to come, the guidance is going to be coming from the CDC, California Health Public Orders, Cal OSHA, and employers are going to be required to comply with all those regulations. The last thing, and kind of helping to hopefully create a positive work environment, is to encourage employees to look out for each other, especially those that might be at the higher risk categories. So again, if you're checking in on somebody, checking in on your workforce, seeing how they're doing, those are all things that we recommend that employers continue to do as we transition back into work. Let's see, next slide. To implement policies and practice to ensure safe and lawful return to work. We have our COVID-19 protocols, a lot of we went through, cleaning, screening, and to actually meet it. You want to make sure you're updating your existing policies to make sure they're current with any revisions that are coming out. And we know that things are changing daily, hourly. We've got revisions, what happened in, I believe, January. Cal OSHA issued those new revisions in January, and then they repealed them, so we went back to the November 2020 order and regulations. It's a very fluid situation, and want to make sure that employers are doing everything that they can to comply. Jen, I see that you raised your hand.
Yeah, just a quick question on this. As we, let's say that the policies get updated, this week. How quickly are we expected to update our policies to align with the new guidance?
Well, I think it's going to be dependent on the agency that's updating. Usually it'll set forth a time period of, okay, these policies are approved and they're effective now. For example, the Cal OSHA ones, as Sammy previously mentioned, they're voting on the proposed revisions Thursday. So, and we anticipate if approved, they will go into effect June 28th. That's a 10-day turnaround. It's pretty tight, but you can go through and review those proposed revisions, which we've done, and we'll include and touch on a little bit at the end of the presentation. So you're prepared. These are new things that could be coming down the pipe, and we should be prepared to have these ready to go just in case. I think it's a fluid situation, and employers are doing their best to stay up to date and keep everything compliant. And I think as long as it's, you show you're making a good faith effort, there shouldn't be issues. But this isn't anything new. Things have been changing weekly, daily for almost the last year. So it's really the duty, unfortunately, does fall on employers to stay current with everything.
And Christine, would you add that too? We like to use a reasonableness standard, right? So, you know, if they were adopted June 28th and we're talking to you in October, we might say, well, I don't know if that was reasonable. But if we're rolling out policies end of July, just as kind of like a, you know, hypothetical, we like to use a reasonableness standard.
Absolutely, Sammy. And I think though here, because we do have the proposed revisions available for review, they became available, I believe, the beginning of this week. So it's not like they're going to issue these policies on Thursday and nobody knew what they were. So I think it's looking at all of the pieces and, as Sammy said, applying a reasonableness standard. Let's go to the next slide, laws and guidance for employers and guidance that employers must consider. So as I'm sure you guys are familiar with, we've a multitude of different organizations that are providing us with guidance and regulations, sometimes always not that clear, unfortunately. The big and overarching one is the CDC. And then I think secondary to them, state, local laws. For us, that'd be the California Department of Health. Then we also have OSHA guidance along with EEOC and the DOL. It's important to kind of see how all these pieces may or may not fit together and to seek appropriate guidance from legal counsel. We would recommend, whether that's Sammy and I are more than happy to help, or if you have your own outside legal counsel, to the extent that anything is not clear, we strongly recommend that you seek the advice of an experienced attorney to help you manage these. Next slide. So again, this is going back to policies, limiting business travel, new policies and protocols regarding cleaning. Job description, that one's a big one. And I don't know how much you may or may not have revisited that during the pandemic, but to the extent an individual's job duties have changed because of the pandemic, or because maybe they're moving into a hybrid role and it's going to be partially remote and partially in the office, any job description or job duties that have been impacted, the job description needs to be revised accordingly. And we'll touch base on this a little bit later, but if the job description is incorrect, it could result in a potential liability either under the California wage and hour, or potential disability accommodation issues, which I'll touch on in a couple of slides. I think the big thing is to figure out how your business can best adhere to all of these regulations and implement them with your workforce in a way that is well received and that is still compliant. Okay. So what does your return to office plan look like? So A, immediate; B, phased, and you're planning on whatever your post-COVID workforce is, have that implemented by end of summer. You're going to have your post-COVID workforce implemented by end of the year. You don't have a plan yet, or none of the above. And I know we had some people join late. We are on poll everywhere, so we'd love for you to join the polling. You just need to text 22333 and text Sammy JL to 22333. And I will give it another couple minutes because I know we have people join from the last poll everywhere. Okay. And I would say that's pretty consistent with what we've been seeing. It's phased. A lot of people targeting the end of summer. I think a big part of that is having to do with schools / childcare, that most people are hoping that by the end of the summer, most of the kids are back in school and that we can kind of return more to a pre-COVID status. All right, next slide, your return to work plan. So we've gone over various orders that you're going to have to consider from the state, local, county level. Want to make sure the proper supplies are there for all of the employees. You have cleaning, screening procedures. They're being implemented appropriately. This one might be tough for some people. If you're bringing people back And whether they're furloughed or whether they are remotely working, you're bringing certain people back for various reasons, you want to make sure that there is a neutral selection criteria for when you're bringing people back. Or I like to use the term legitimate business reason, because for whether you are or are not bringing a certain person or job back. The concern here with how people are being brought back, and to the extent that there may be any different treatment for different employees, is that there's always the concern of potential discrimination or retaliation. And, you know, I was left, or I was told I couldn't come back to the office, or they made me come back to the office because of X, and you can insert whatever protected characteristic you want there. But that is definitely something that employers need to watch out for. Further, while not specifically identified as a protected characteristic, it could be considered one because of either a disability or political affiliation, employees' feelings or stances on vaccines or face coverings. So that kind of stuff should not be considered when you're bringing your workforce back. You want to come up with a neutral way to do that. And usually a good kind of recommendation is you're not picking people, you're picking job functions that you need back in the office. So for example, if you have a mailroom clerk or somebody who needs to physically come in and stock shelves, that's a job that needs to be done in person and can't be done remotely. So things like that to take into consideration. And again, to the extent you have an employee who is uncomfortable coming back, and even if you may not believe that the employee is legitimately uncomfortable, you want to make sure you handle that, address it. Every concern should be deemed valid or considered valid and addressed in an appropriate manner. And I think that's that. So develop a return to work plan. So kind of briefly touched on this regarding changes to exempt status. So this goes for bringing people back in and re-examining the job duties and descriptions that people are doing. So if somebody is working remotely and their job description has changed, this could change their exempt status. In order to be an exempt employee under California law, that employee needs to be performing exempt duties more than 51% of the time. There are other requirements that go into qualifying an employee for an exempt status. However, that is a big one, and you need to make sure that if there's been a change in what the employee is doing, that they still qualify as an exempt employee. If an employee is improperly classified as exempt versus non-exempt, this could lead to a slew of California wage and hour issues. For non-exempt employees, we need to keep track of time. They're paid hourly, meal and rest periods, overtime. So this is important that we take a look at this to the extent an employee's job duties have changed. Additionally, with respect to job duties, that's one thing that you look at when you get an accommodation or a request for work restrictions from an employee. So if your job duties and descriptions are out of date, you can't really properly identify whether or not this employee is qualified to perform the essential duties or job functions. So you could run into an issue with accommodations and engaging in the interactive process with employees if your job description is not up to date. Other suggestions for returning to work, there's work share and unemployment insurance implications. For California, I know we like to use the word furlough a lot, and we furloughed employees because we intend to bring them back, for example. California doesn't have a furlough. I hope someone has advised you of that if you did have to furlough employees. And furloughing employees is akin to a termination or separation of employment in California. So all of the separation paperwork should have been completed and gone out whenever that employee was furloughed or separated. Now, if you're bringing employees back on, you will need to also onboard them as you normally would. And this means I-9s, onboarding, employee handbook acknowledgements, new policies, and whether or not you do this remotely, that is up to you, but you'll need to have a policy and a procedure to do that. One important thing with the I-9s is it's the employer's duty to review the documentation and to verify that it looks authentic and correct. So you will have to come up with a procedure to do that, whether you have the employee drop off documents or come in person and drop them off and you have somebody there to review that. You want to make sure that is laid out. Next slide. Challenges with remote work. So I'm sure you've seen this where you have some employees that are thriving with remote work. They are uber productive, and they're one of those employees who, well, I would normally get up at 8 to get to work at 9, so I'm just log on, I'm gonna start working at 8, and I would normally get home at 6, even though I end work at 5, so I'm gonna work from 8 to 6 instead of 9 to 5. And they, they're working, they're being responsive, they're productive, everything is great. And you probably have some employees where you send them an email, hey, can you get back to me ASAP, radio silence. Follow up in the afternoon, hey, we really need to just meet to discuss this, further radio silence. Send them a follow-up email or try and call them the next day, nothing. So I know that the employees have probably run the spectrum on this and how remote work has worked for them specifically. Still need to address remote work on a case-by-case basis. I'm going to emphasize the flexibility. This might be a good time if you're going to continue to allow an employee to work remote work or work from home, that you reset and you identify and go over the job expectations, especially if the employee has not been meeting them. Make sure that you document everything. You make sure that you communicate your willingness to work with an employee. For example, if they are expressing they have other personal issues going on at home, and that's impacting their performance. This is a time to be flexible. If any issues arise during this time, I could see a jury being very sympathetic to an employee who has been stuck working remotely for a year and is experiencing other personal issues. So making sure that we are being considerate of all of those. Another thing with remote work challenges, and hopefully this should have been addressed, is security risks. Non-exempt employees, if they're working remotely, ensure systems are in place to properly track the time that they're working. We want to be aware of off-the-clock work, late night emails, etc. You want to make sure your managers or supervisors are properly trained and recognizing when a non-exempt employee may be working off the clock, and I'll go through a couple examples later, and making sure that you're communicating to employees when there are issues. Okay, and now we'll go over, Sammy will take over regarding accommodations and COVID-19 issues.
All right, so I'm sure that a number of these quotations are things that you've heard or will hear in the future. And so what we're seeing are, requests by people who are part of a vulnerable population, or perhaps caring for somebody that are part of a vulnerable population. Perhaps employees are expressing concern if they're aware of a COVID-19 exposure in the workplace. Or maybe they just have anxiety about coming back to work. As Christine, really highlighted, what we are encouraging is flexibility. We want to be empathetic and sensitive to employees while also balancing a sense of consistency within the workplace so that it doesn't seem like you're treating one person differently over another, because that can lead to bigger issues in terms of perhaps discrimination claims or retaliation claims. We want to make sure, again, that we're training our managers. How do they handle these situations? How do they escalate it? Do we have HR? Well, should the manager then take, an employee who says, I have a lot of anxiety about coming back. I'm having a difficult time today. Can I work from home? What would we tell our managers, to say in that situation? Well, hopefully we can be flexible and say, yes, we understand. We'll go ahead and permit you to work from home today. I'll let HR know so that the proper documentation gets to where, essentially it needs to be. Now, here's the big question that probably everybody is wondering. Well, what if an employee refuses to return to work at all? We would say that it's important to make sure that the employees provide essentially a reason in writing. It's documentation. That way we have it. We have a record of it. I can't tell you how many conversations we've had with our clients and they say, well, I sort of remember talking on the phone one time, or I might have a sticky note somewhere. I think it's fine to the extent, if the employee sends an email, or perhaps you do have some sort of memorandum that you keep for employees who say, I don't want to come back to work. The next step would be looking at what's the reason. Is it because they actually were exposed to COVID and they need to quarantine, or they're sick and need to remain home? Are they caring for somebody? You know, what is going on? And from there, we start to look at what types of leave might be available to an employee. Perhaps do they qualify under FMLA or CFRA? Are there sick leave, or are there local ordinances that might apply in this situation? If protected leave per se is not applicable, then do we need to look at a disability accommodation analysis? It's probably one of the most frustrating things for employers is to go through a disability accommodation process, because you need to engage in the interactive process. We need to see what work restrictions are in place. You know, if there's a medical note that was submitted, what does it mean? Can we accommodate you by allowing perhaps telework or different, or perhaps could they be on a leave or an unpaid leave? And so it's important to make sure, I think, first and foremost, that we're just training our managers, or sort of that front line of who an employee would come into contact with, because they are at that moment sort of the face of the company, and our response, we don't want that to be an issue later. In terms of should we engage in the interactive process, we need to consider, are they part of a vulnerable population? Are they caring for somebody who has COVID, or somebody who is part of a vulnerable population, or perhaps has their medical healthcare provider taken them off of work because of a condition? So like I said, some of the potential accommodations could perhaps be continued remote work. Is this something that's now possible because we've actually looked at the job description, we've evaluated what their daily duties are, and is this something that can be performed remotely? Perhaps we might need to consider a leave of absence, whether it's paid or unpaid, depending on the circumstance. Another point that we might need to be looking at is just additional safety precautions. What have we done? Do we have kind of the clean it, mean it, screen it? Are we actually following what we're saying we're doing? Are our managers well-versed in what these policies are, so that the employees do feel comfortable coming back to the workplace? And so another question we often get is, well, this employee submitted a doctor's note, you know, they're off of work for a week. Can I terminate them? Well, probably not the best idea. It's a case-specific analysis, but you do want to be mindful and keep track of what are the accommodations, what is the medical condition that you are accommodating, and then looking at how long do I need to continue accommodating this individual. We understand that, you know, it can be very difficult on the business and perhaps create an undue burden at some point in time. And then perhaps there's a situation where we might have to part ways with an employee. But we want to make sure that we're being flexible and reasonable in these situations. Other accommodation issues that we're seeing is essentially people just saying, well, I don't want to wear, you know, the personal protective equipment, but Cal OSHA has, you know, very specific regulations, you know, masks are still required. And so we want to make sure that we're following those policies and staying up to date. Childcare is another issue that we're seeing, because some people just have not had, you know, their kids in schools, or perhaps they were remote. And so there's issues when children would normally be at school and now they're at home and you're working. Right now, there's really no law that addresses kind of childcare issues. But again, we just say it's important to remain flexible in these situations. Can you allow the employee to continue to work from home? And also be aware that some of the local ordinances may allow for time off for childcare issues, but want to make sure if we're developing policies, there's not a disparate impact, essentially treating one person different over the other. And lastly, employee morale. You know, can you allow somebody to work from home for a week or 2 weeks, or 1 week in June and 2 weeks in August because they're having childcare issues? If the answer is yes, I think that just boosts the overall employee morale and for working for the employer. I'm going to move through sort of kind of some wage and hour issues, but also just talking about time clocks here where on-site employees, time clocks can be in a potential infection point. So we want to make sure that we have, whether you have wipes right there, things can get wiped down. Just making sure, again, that employees are going to feel safe because you have the proper hand sanitizer, wipes, and different things there. Another thing is social distancing issues. Perhaps you want to consider staggered schedules so that everybody's not rushing into the office at one time. In terms of social distancing, we've also seen employers having questions about, well, what about the break room? Where do employees go? If we're forcing employees to go outside, is that going to create actually wage and hour issues because now they have to spend more time going outside as opposed to they could just clock out and go right down the hall to the workplace. So we want to be mindful that if we have those policies that are requiring employees to travel further distances, that we're going to compensate from them for that time. We'll move through, just because we're short on time, talking about essentially just compensation for medical inquiries. So courts have held that time spent undergoing security checks is compensable. And so we sort of, at this point, there really isn't a lot case law because it hasn't been widely litigated, but we're thinking that perhaps, time spent doing temperature checks would be compensable because it would be akin to essentially a security check, and you are requiring an employee to make a stop and take additional time before they can actually clock in for their position. Let's see. Christine, I'm going to jump ahead just because we're short on time. But last thing would be reimbursements, which I think you also discussed kind of at the end. So I'm going to move forward for you. Although before we go over this one thing I want to note for the remote, the timekeeping on the remote force is to keep an eye on this. If you are texting somebody at 8:30 or 8:45 and they don't start till 9, you are starting, theoretically, they're off the clock work. If they are emailing you at 8:45 and not 9, that's work, and you need to make sure that they're being properly compensated for this, or else it's going to result in very, very big problems down the line for California wage and hour. And I don't know if there's another way to check this to see when they are or are not accessing their system. So if you notice somebody is always online and doing work, maybe not sending emails, but doing stuff between 7 and 9 p.m. every night, but they're not clocking in for it, you need to make sure that that employee is being compensated or that is addressed appropriately so that there aren't future penalties, liability as a result of that. Okay, let's go to the class actions. We'll avoid those at all costs.
Or they're the worst. Okay, let's go to that slide about the updates, and then we'll finish up with the vaccine stuff. One thing, next slide. Reimbursement. I think just the big thing here is cell phone reimbursement, and to the extent it may be applicable, internet. Just keep an eye on that. And then next slide. With cybersecurity, and if your workforce isn't working at home, you should already have a robust cybersecurity policy, and employees should have an understanding of how to keep the company's and the company's clients' confidential information protected. Next slide. COVID, how are you receiving updates regarding COVID-19? Are you going to Cal OSHA? Are you reviewing the website? Is it webinars like this? Is it something maybe a little bit easier? So if you want to just put in the word Google, so if you just text like, do you have outside counsel that is assisting you? Are these type of webinars that you're going to stay up to date? As we've discussed, yay, Jackson Lewis. As we've discussed, there's a lot, and they are always not consistent with each other. And it's a lot to kind of digest, manage, and to make sure that you are creating a cohesive and compliant policy. Yeah, Google's my favorite, man. Let's see, outside counsel, yeah. Google counsel, yeah. Lawyers are helpful most of the time. Unless they're on the other side. All right, so yeah, I mean, Google, I'm going to be honest, Google has some really great articles on it sometimes, but I definitely think Counsel is key and critical to make sure you're getting good information, it's relevant, and you can rely upon it. Let's go to the next slide regarding the vaccine rollout. As most of us are aware, California, next slide, please. Yeah, we've rolled out the vaccines. As of right now, there's no requirement for employees to get a COVID vaccination. There's nothing under the CDC or Cal OSHA. There's a possibility that a new law could go into effect, but that is not the case right now. Next slide. Regarding employee vaccination mandates. Right now, there is nothing prohibiting an employer from mandating its employees get a vaccination. If this is something that you believe your company is considering, you need to make sure that you comply with the 3 requirements on the slide, that you can't discriminate or harass employees or job applicants based off of protected characteristics. This means if an employee is not able to get a vaccination because of a medical condition, that they don't suffer any disparate treatment. We must provide a reasonable accommodation if an employee is not able to get a vaccination, and that employers may not, which would be potentially complaining that they have to get the vaccine, for protesting that they need to get the vaccine if this is part of your mandate, or having a protected characteristic such as a disability or a medical condition where they're unable to get the vaccine. So it's important, if your company chooses to go this way and mandate that its employees get vaccinated, that you are complying with these 3 requirements, which are currently into effect. My guess is there will be more instruction coming out shortly. DFH, proof of vaccination. You can ask for proof of vaccination if using a third-party administrator. The request should instruct employees to omit any medical information or documentation, and this information is confidential. It is confidential and protected under the Confidential Medical Info Act, CMA, and under the ADA. So whoever is collecting this information needs to keep it confidential. It cannot be dispersed throughout the company or to other employees. Next slide, resources. So now that we've all lived through the pandemic for the last 100 years, we've got some resources that we want to make sure you're aware of. If you need links for these, you can contact Sammy or myself. Here, the next slide has some specific California state resources on it. The LWDA, EDD Coronavirus 2019 page, and our ever favorite Cal OSHA. Next slide. Sammy and I are working on finalizing a handout. We are waiting for the voting to finish regarding the new Cal OSHA requirements. It's going to highlight some of the big ticket items we've gone over, along with some of the big ticket items and revisions that Cal OSHA may or may not enact. Some of these, for example, regarding respirators and requiring employees to provide respirators to employees at no cost, reporting to local health authorities, confirming or not confirming whether an employee has been fully vaccinated and what that looks like, along with other requirements. So if that is a handout you are interested in receiving, please email Sammy and myself, and we will make sure you get on that email list once we get once the board votes, and assuming they do vote to or not do something, we will include that in the handout, which will go out next week. And that is it. If you have questions, I believe there is a link that was sent forth in your invitation that you can send questions to. You can also email Sammy and myself if you have questions. We apologize that we ran a little long and did not leave enough time for questions today, but we thank you so much for taking time out to sit through the presentation, and hope that you all found it informational and helpful. And Jen,
thank you so much. Yeah, thank you, Christine and Sammy. And I know I'm looking forward to your handout when it becomes available, and I'm sure that others are. Thanks so much for taking the time today and for providing that, once there's more guidance.
Awesome. Thank you for the invitation.
Take care, everyone.
Bye.
Bye.
Bye.